let's even start from what SERAP is saying about UN-backed commission. You want to address that?
Well, that's, I want to say, perhaps emanated from the fact that in the considered view of SERAP, that judiciary has actually failed. If they have not seen it from that perspective, I don't think SERAP will want to approach the UN to come in to have a backup in our perhaps investigations and eventual prosecution in the courts. But be it as it may, you begin to look at it. Would there not be jurisdictional issues in respect of UN coming in to be involved in the prosecution of certain cases that we see as being high-profile cases and all that? But if you want to say, well, yes, UN should come in to help inform and in terms of manpower, give us the necessary aid in prosecuting, give us the necessary aid in investigating, and if the prosecutorial agency has the wherewithal to prosecute, perhaps there won't be any failure from any quarter in prosecuting to the end. But SERAP calling on the UN to come in, I don't know from which perspective they want them to come in.
Okay.
It has to be well defined.
All right. Yes. At the beginning of my story, I talked about more work being done,
yes.
In terms of Nigeria's criminal justice system.
Yes.
What more work needs to be done in terms of Nigeria's criminal justice system and what is on ground?
Well, you see, it is rather unfortunate that in our criminal adjudication here in Nigeria, what we have is an adversarial kind of procedure. The state sees you as guilty already. You have been indicted, but the state sees you as guilty and then asks you to come and prove your innocence.
No, sees you as not guilty.
The state sees you as guilty. That's why I said it is adversarial. The state sees you as guilty and then, I'm coming, and then wants you to come and prove your innocence in court. You know, if it was not adversarial, what you do is you keep a tab on whoever you are investigating. You get your necessary investigation, get your documents, you get everything intact. All you need to do is, after you have done that, you now come and place those things before the person and ask the person to react to them properly by making statements. You understand? When you have done your investigation, proper investigation, by the time you want a watertight prosecution, you want a situation where your prosecution of that person will not be affected in any way. You don't want puncture. You don't want your prosecution punctured. That is why it is necessary for you to do proper investigation. And when you have done that, you now face me with those your investigation results or reports and ask me to defend them. While defending, I need to make reports, make statements, quasi-judicial statement at that point in time. When that has been done, and you have even you will use your investigation reports to begin to question me and ask me to write my answers down in a statement. That statement is a quasi that's prior to you coming to court, or we found that your responses to questions asked are not proper. And if you are still unable to whatever you say, even in your statement, will not deter what has been found in the investigation.
All right.
So that is the basic. It's the preliminary thing that ought to be done. That is why I said, but the way we do it, you just say, oh, this person, we assume he has done this, and then we go all ahead and say, come and explain to yourself without you investigating first.
Well, that's contrary. I interviewed, was it day before yesterday, Dr. Fassi. Yusuf. Good. And he was talking about the fact that in other crimes, that what you have is that in some crimes, that just what you said, that they hold you guilty, then you come and prove your innocence. But here, that you are not guilty, you're not guilty, you're regarded as not being guilty, while going to court. But you're saying it the other way. All right,
Let me get the explanation well. I said it is adversarial. Being adversarial is is to say that, look, this person, as he is now, is guilty already. That's why, in other crimes, I've been in other crimes, they conduct discreet investigation without you knowing that there is a tab on you, and they go on ahead to get information, get all their documents, get all the necessary things, and then they face you with it.
Let's just take it a step further, and not just dwell on there and lose the whole essence. Monday Ubani, you know him, former NBA president here in Lagos, was talking about. Okay, good. Yes. Yeah, we're talking about the court seeming to use technicalities to quash corruption cases instead of concentrating on the substantive, issues. You want to talk about that?
See, the law is clear. The law is certainly very clear in this regard. It is not issue of technicalities. Where you have issues of technicality coming up that the ACJA and even the ACJA as you have in the Act.
Yeah, the Act.
Yes, Federal High Court and all other areas. And the ACJA as you have in Lagos and other places. But one thing is very, very, very certain and very clear, that issue of technicality will not come. Technicality in certain respect will be when, I will address it fully, when, well, yes, there is an objection raised during the pendency of criminal trial, prosecution in courts, and then the defendant, in one way or the other, intends stalling the procedure or the proceedings in court and now says, look, I am objecting to this and I'm appealing. Maybe I want this court to give a ruling one way or the other on it. If ruling is given and you are not comfortable with the ruling, you want to appeal and you ask the court to stay proceedings. It's technical. Okay. But then the ACJA has frowned at that. The ACJL has also frowned at that. Now the Supreme Court has just given judgments in respect of that. Just last month to say that no judgment, no proceeding in court, in criminal court, will ever be stayed again. That has not laid that to rest completely. Now, issue of technicality is this. We have sections in the law where you feel as a defense counsel that you have gone through the rigors of prosecution, and after the prosecution closes its case, you feel there's no need for the defendant to enter into the box.
All right.
You now come up with an application of a no-case submission. When you make your application.
Now you've raised that.
Yes.
Now you've raised that.
Yes.
Now you've raised that. The question of no-case submission, correct me if I'm wrong,
yes.
It's supposed to mean that in this case, the Senate President wasn't even allowed to come defend himself. Is that what no-case submission means?
That's precisely what it is.
And if that's the case,
yes.
Why did that happen? Why was that allowed to happen?
No, it is still the law. See, let us be clear. See, we need now to begin to ask whether indeed it was right for the CCT chairman or for the tribunal to have allowed the man to go on no-case submission. No-case submission, you are saying, is to say that, my lord, at the end of this prosecution's case, I have found, or there is nothing whatsoever that has been said against my client worthy enough for him to enter the witness box to give evidence to defend himself. Do you understand? Or to call witnesses to defend himself. That is no case. But if otherwise, the court sees it in another angle and said, no, look, I want you to come and give explanations. Explanation, that is what can override a no-case submission. Look, you have stated that these people have come with so much documents. They have come with the witnesses that come. Whether there is something there that the court has listened to and who wants the
prosecution.
The defendant to come and give an explanation to. Look, this person said, look, in 2008, you acquired property. And you didn't declare it in 2009, your asset declaration form that you filed. You didn't declare it in 2012, 13, 14. You only declared it in 2015.
Good.
I wish you had all the time. Let me quickly just end that. That is one of the reasons why the court will have said, look, because you didn't declare, and they are saying this was one of the things that you did, that we have brought you to court. Come and explain why you didn't do that. So I want to say you shouldn't have succeeded on that level.
All right.
Because there is something to say.
All right.
You shouldn't have succeeded.
I want to thank you. I've been talking with Olanrewaju Ajanaku, constitutional lawyer. You raised up another issue, but I don't have all the time in the world to address that one. The question of the fact that it was being said that one of the witnesses said that he did this, but because there was no document. But we don't have all the time.
There were documents standard.
We don't have all the time. We don't have all the time. Thank you very much for your time. Thank you very much.
It's a pleasure being here.